We're live, Will.
Awesome. Hello, Melanie. I'll do an introduction of you because I've known you for a long time. You're a big time lawyer now. Melanie Williams of Law in Motion. She can be reached at 905 419 04. My notes are awful. 04 what?
89.
8989. And your website is lawinmotion.ca. Thanks for joining us today. We think during this whole time, when we're going through this craziness, I think it's important to get levity, especially from someone that's sort of dealing on the front. I mean, you are on the front lines because being a lawyer, you're getting a lot of calls from different people in different industries, different things going on in their lives. We want to discuss the whole thing now that we're working virtually, and you want to discuss a bit of on signing electronically and sort of what's going on with that and sort of the ins and outs.
Definitely. So it's kind of a different world right now as far as signing goes, right? So if we're looking at different areas of law, so for instance, in my practice, I do wills and estates, real estate, and corporate commercial. So if we're looking at signing electronically in a real estate environment, in that context, we're able to, bring the client up on Skype, FaceTime. There's a ton of different apps. I don't really know them all, but I simply just ask the kids, they download it and show me how to use it, quick crash course. And then we go from there, right? So we bring the client up. As long as I can see them, I can physically see the pen that they're signing with. We don't have the ability to use DocuSign. Like I know in real estate, that's a big mechanism used for signing. But for us, we're still kind of working in an older school generation where we have to physically see and verify the client signing those documents and witnessing that signature. Now, the government came out with some new legislation that speaks to what happens in the context of wills and powers of attorney as far as signing, which I know we're going to chat about that a little bit.
Right.
Right now, we're just trying to do everything we can to keep clients moving forward with their real estate deals, with corporate transactions, and all of those things, and electronic signing. No matter what the medium is, I will download it and figure out how to use it and get them signed up.
So are you then mailing over to the people then contracts? They get it in the mail, they open it up, they do a Zoom or whatever with you, you see the blank contract, they put the contract down, they sign it. That's how it's going?
Basically, so and I don't necessarily mail the documents, like I email them, they run them off. If they don't have the ability to print, then
I thought as Will was going on with that, I was like, you really have to mail it these days?
Yeah, so we email them.
Not everyone has a printer. Like, I don't have a printer.
Yeah, if they don't have a printer, then I print them and put them in the mailbox and they pick them up. And then the same idea. So I've had circumstances where clients don't have those electronic abilities, right? So they're sitting outside of the office in their car and they're signing the documents so I can physically see them through the glass. So different ways to make sure that clients are still getting signed up and it's working. But it's a challenge to actually see them signing, right? So they turn the screen down so that I can see the signature and then they hold it up once it's done. It's just a new world that we're living in.
Now, do you have to get their hand and body in the full shoot?
Well, not always easy to do.
Well, that's what I was thinking, because if they put the camera down, then you're going to see their hand signing. But what if it's somebody else's hand? Right?
Yeah, there's always the risk. There's always a risk.
Wow.
Right. So when it comes to then, so with this time, so you did briefly mention wills.
Mm-hmm.
So if someone, let's just say someone is, now that there's downtime, people typically, I would say, should be thinking about doing things that they would never typically do when they're busy. How would someone go about getting into, starting preparing a will or whatever?
So I think we're getting a lot of calls from people looking to get wills done, powers of attorney. Everyone's feeling very mortal right now, right? So, and because of that, we're trying to find out new ways to do things. So if you were to create a will prior to all of this, you simply give your instructions, grab 2 witnesses, independent of the will. So no beneficiaries, no beneficiary spouses, no one who's really named within the will should be acting as a witness. So you grab two individuals and you sign the will. You can still do that. So the question is, for people in long-term care facilities, are nurses willing to act as witnesses, which typically they're not?
Okay.
And where do you find those two independent witnesses outside of your primary caregivers? So the government has come out with the new emergency order that says, as long as one of the witnesses is a licensee, like licensed by the Law Society of Ontario, then you can do these witnessing electronically. The concern for us is that, again, a lot of seniors who are looking to take these steps don't have these social platforms or the internet capabilities or the understanding of how to use those systems. And then on the flip side is, if they do have that level of expertise, how do we make sure that on the other side of the camera, there's not someone with a gun saying, name me as your beneficiary and give me all of your jewelry, right? Like that's an extreme, obviously, but we don't know how to determine if there's any sort of undue influence. Is there people in the background that are not necessarily supposed to be there, right, when they're giving instructions?
So in this time then, if someone wanted to do a will and they're in a long-term care, or update their will, let's just say, and they're in a long-term care home, how would you go about then witnessing or sort of getting these changes implemented?
So I've had a couple of clients like that. Now, it's a bit different because if it's a client that I've never met and I've never done a capacity assessment, I've never spoken to them, because I typically determine capacity in an as is, where is situation, right? So when I go to see the client, if they're having a bad day and they don't have capacity, we don't do the documents. But if I attend at the client's place and they're, I know that they're not well generally, but they're able to tell me what the condition of their assets are, what they own and where they own them, all of those questions that gives me a sense of understanding of what they have and what they know, then we sign the document. So if it's a client that I've dealt with in the past who's calling me to say, this is what's happened, a child of mine has passed and I want to change my documents, then in those circumstances, because I've already gone through the whole exercise of confirming their identity, then I try and make sure if they have the ability to sign those electronically, as in, is there anyone that can set up the Skype or set up a FaceTime call for them that I can see them and speak to them and kind of get a sense of their surroundings and their health on that given day. Now, a complete stranger who comes in or calls in and says they want to make changes or create documents from scratch, in those circumstances, it's always a little bit more difficult because I don't have that past relationship. But same idea, we go through the questions and send out questionnaires to try and figure out where their assets are and where their mindset is.
Now, how would somebody change? So let's say they had their will done 30 years ago with some other lawyer, and now they come to you to make changes to it.
Yeah.
How do they, if they don't have their copy of the will, what can you do? If anything.
We reach out to previous counsel to find out if the will still exists in their office. So even if they may have given out the original to the client, typically older lawyers have a physical copy somewhere in their archives. Or for my office, I always have electronic copies with some kind of a note saying where the original is. There are two safes, one in Bowmanville, one in Marmora. So each of my office has a location to leave their will, should a client so choose. But if they do choose to take the original, then we just have a note in the file that says original was picked up on X date. So granted that the other counsel's records are okay, we should be able to track down at least a copy of the existing will.
Interesting. And then if someone wanted to then start the process of a will, then I guess the process typically is they go to your website, lawinmotion.ca, and there's probably a form on your site that they can fill out or call you. Like how do they start the process?
Yeah, so the forms are not online because they're, what we don't want is people to download the form and then take it and run and believe that it's some kind of legal directive on how to create a document. So the process is they call in or they send an email, And they get that information on the website, and it will direct them to get a copy of the questionnaire, and then asks them very standard introductory questions: where they live, what the state of their assets are, who their beneficiaries are, if they know that, who they're interested in appointing as executor. The more information we can gather up front, the smoother the process goes once we start meeting with them online.
Perfect. No, that's pretty good. And then also, Dan, you're not really asking any questions here.
You got the whole list. I'm just waiting till you go in, and then when something pops in, I'm waiting for the whole shareholder discussion, Will.
Right, so that's where I'm going to now. Shareholder discussion.
Okay, I got this then. I got this one. I got it.
Oh, good. Thank you.
Yes,
Go right ahead.
Melanie and I have worked together on a couple of these, so I've learned. So Melanie and I, we met back in September through you, Will, and yeah, you're a wonderful person. So, but I learned a lot of things from Melanie about shareholder agreements and how they're actually supposed to be done, as opposed to the way that 95% of the people that we see shareholder agreements for do them.
Right.
So the first thing is, because we deal with a lot of small corporate clients, and a lot of them don't have anything in place. So we start by telling them about why they need a shareholder loan agreement. But the question I wanted to start with was, if it's two related parties, husband, wife, brothers, sisters, if they're the sole owners of a corporation, should they have a shareholder agreement in place as well?
So that's kind of like a, what's the phrase? I guess a catch-22, right? It depends on the nature of the business and on the nature of the relationship, right? So let's think it's two brothers, each are married, they have their own families, and they're running a business together. Now, one brother passes away. The assets in that corporation form part of that brother's estate, right? Which means now all of a sudden brother's wife or someone else is now stepping into the corporation in a shareholder's role, which basically no one wants, because they have no connection to the business or no understanding of how the day-to-day operations run. So a shareholders agreement preempts that from happening, right? Typically they speak to what happens if a shareholder is disabled or passes away, right? Like how the corporation recaptures those shares, or if there's an insurance policy, how that gets paid out, right? It dictates all of those situations, so prevents any kind of uncertainty. Now, if it's between brothers and they have a side agreement where something happens, the other brother just assumes the shares, or it's named in the will, then it's not as big of an issue.
Okay. But that is something that should be explored, though. If someone is like, in my case, a real estate agent, and you're looking at maybe incorporating or whatever, it would be important to sort of look at all possible potential risks to the corporation with a lawyer, obviously.
Yeah, absolutely. And then if there is, as the corporation grows, maybe there's a need for like a corporate will, which severs out those assets from the main estate, right? So all of those different avenues that you just need to get a feel for the situation to really ascertain what applies to each corporation.
And the corporate, and this because I'm playing dumb here, the corporate will is separate from
That's
your
right.
personal will, right?
Yeah.
So
Yeah.
just gotta say it.
No, I'm telling you, everybody who incorporates should call Melanie just to have a once over, because so many companies, they incorporate, they go online, and you can go to 100 different companies online and just download, and they'll send you out your little, I did the same thing. They send you out your little binder, which gives you your articles of incorporation and like 50 blank pages of stuff that nobody ever looks at again. And when I went into Melanie's office, she said, well, did you keep these notes? Did you sign off on this at the year end? Did you do this, and this? And I was like, no. And I'm pretty sure that like 90% of clients, they don't either, right? So why don't you give us a quick rundown of what clients should be doing with that binder on an annual basis?
So they should be reviewing it, right? So go through the binder, see if anything's changed it. Look at those original articles of incorporation, see if there's any amendments that need to be made. Look at your bylaws, make sure that the borrowing bylaw with respect to the banking is there. see if there's any caveats or restrictions on how much the corporation can borrow if it needs to borrow money. Look at all of the resolutions, make sure that all the directors have been properly appointed. If there's been any changes in directors over the course of the year, make sure that the updating resolutions are done to replace the existing directors. Every year there should be annual minutes done. So the accountant, as you know, will provide that statement that says whether any dividends were paid out or any shares were redeemed. All of those things form part of the accountant statement. We take that statement, prepare the minutes, and it just captures all of the updates. And then directors and officers, well, not officers, directors and shareholders sign off. And then the key to those books is just making sure if you're ever audited that they're up to date.
Right. And then so are you saying then a corporation, no, big or small, should have minutes, should have a yearly, at least a yearly review of their operations?
Absolutely.
Okay.
Yeah, that book, regardless of the size of the corporation, needs to be maintained and should be updated on an annual basis. At least months.
So many are not. I mean, we see tons of people who get their incorporated documents, but then never actually go and see a lawyer to have any shares issued.
Right.
Right? Like that's a big step, but most people don't do it. They just get that binder. To open your bank accounts and everything else, all you need are the articles of incorporation. And then that binder, like one guy brought me his binder in just a couple of weeks ago. This thing was so covered in dust. Like I could have peeled full fingerprints off it once he handed it over, right? Like that thing's never been opened since the day that he got it. So, but these are things that businesses really should be putting as a priority to make sure that these things are checked and that they're properly set up. Because Melanie's right, you don't really need it until Canada Revenue comes with an audit and asks to see it. And then what you're doing is you're trying to scramble to make these things up for the last 4 or 5 years.
Right. So in those cases, though, we can do like a ratification, right? So if you don't have the records for the last 4 years or so, then we ratify all of the events of the directors from X date to the date, like to present day. And it just brings the minute book into good standing. Now, I don't recommend ratifying for like 25 years, but if it's only a couple of years and not much has changed, then a ratification might be the quickest way to bring the minute book into good standing.
Right. So you have clients that are, mom and pop kind of corporations. I mean, both of you guys up straight to like large corporations and basically the corporational, I guess, the operations of how the corporation works are similar. I mean, I guess if you're a larger organization, you probably want to meet more often than once a year versus a small, right? So the operations are still sort of similar?
Yeah, so the minutes that we file are standard across the board. The only differences would be maybe as the corporations grow, they have more shareholder dividend payouts or bonuses that they've declared in the past year, all of those things that we capture in the resolutions. But the basic minutes for a Canadian controlled private corporation, right, less than 50 shareholders would be the same across the board.
Right. And then what kind of businesses are typically incorporated?
Everything.
The sky's the limit.
Yeah, like everything.
Well, okay, all right. So then another question. I'm asking questions. You two are the experts, it seems. Here's another one. At what point in a business do you believe you should incorporate?
So I think from my perspective,
right,
I think it depends on the trajectory of a business, right? So if you're thinking you're going to be a sole proprietor and the sole proprietorship works for you, then there would be no reason to incorporate, right? Or if a partnership works. So it just depends on sitting down with those individuals that are saying, what type of business vehicle do I need and what makes the most sense for my platform and where I'm going. When clients come into me without any sort of idea, my first thought is that they need to speak to an accountant to figure out what makes sense for them, because we don't see that side of things, right? The referral should always come through an accountant or after a consultation with an accountant to say, these people need a corporation set up and here's the parameters for the share structure.
So I have a follow-up to that then. So the biggest reasoning that we get for people who incorporate when they really shouldn't is that they were told that getting an incorporated company absolves them of any legal liability in that company. And I make the same face. So I'm glad that you just made that face, right? Because I don't believe it, because every loan that I've ever had to sign on behalf of my corporation, I've had to sign personally as well anyway, right? But it's amazing how many people, when they first come to us and they're incorporated, and I always ask the question, because like for me, the incorporation question comes down to how much money you're taking out of the business.
Right.
Like if you're taking out all of the income in order to live, then the corporate structure serves no purpose. All it does is it makes us more money.
Right, exactly.
Because they're paying for a lot more in accounting fees, they're paying a lot more for their corporate returns and all of that. So because really, to me, the only benefit is the fact that you're taxed at a much lower tax rate within the corporation. But people have this notion that if they incorporate, they don't have any more legal liability and they're free in case they get sued. Can you shed a little light on that for me?
Sure. So again, it totally depends on the corporate structure, right? So those type of, I guess, sheltering that they're looking to accomplish, that type of sheltering would happen if they are the shareholder in the corporation and they've hired 3 directors to act on behalf of the corporation. Now, those directors are out making the day-to-day decisions and they make a huge mistake and the corporation gets sued. So as a director, you're, basically liable for the decisions that you've made, but then it protects the shareholders. Now, if you're a director, shareholder, officer, you're holding every position because it's you as the face of the corporation. But the protection is lost, right? So, and even in those circumstances, the corporate veil can still be pierced if it's found that the shareholder is the one who's actually pulling the strings of these directors, right? If you are the directing mind trying to hide behind the veil, their protection doesn't exist either. So if they're thinking, if that's the sole reason for incorporating, then that's not a good reason.
I literally spoke to a client the other day that makes approximately $60,000 a year in income, and they're incorporated. I'm like, there was absolutely no point. And I said, what made you decide to incorporate? And they said, well, I didn't want the legal liability because I'm in a business that could potentially be sued, right? And now this person is going to be paying a relatively high percentage of their gross overall revenue to have all of their accounting work done. And there's absolutely no reason for them to be incorporated whatsoever. And the dissolution process is a pain in the butt too.
It is an absolute pain. Yeah.
So I'm glad that got cleared up. Now, I do have a question though, because I didn't know that. That's very, very good. So those directors though that they hire, they have to be paid, right?
Yes.
Okay. So basically the only way that works is if I start a company and I don't even want to run the company. I just want to start it and make dividends or whatever. And I've now hired people to do the day-to-day operations and the running of it. And I just sit up there and collect my dividends. Then I've got that bit of protection.
Well, and that is a very wobbly chair you're sitting on, because if the court were to say that, like, shame on you, you have this company and you have not played any sort of active role, right? Like, so in those circumstances, if you want to be completely, released from liability, then you have to structure it a little bit better than that, right? You have to build in the layers and figure out what's going to work, right? And that's when you start having those discussions of, is a holding company the right idea? Would we go to trusts and things like that, right? So it gets very complicated very quickly. But if it's, again, just you sitting behind a chair and, still kind of pulling the strings, there is no protection for that type of shareholder.
So I've got another one then, because I have clients that talk about this all the time too. Now, getting into that whole holding company trust issue, that seems like an awful lot of convoluted work for a company that might be making even up to $250,000 in total revenues.
Yeah,
right.
It is a lot of work. It's extra filings because each holdco would have its own separate tax account. It's also extra minute book maintenance fees. So again, it boils down to, is it worth it, right? So a single guy, who's part of a, let's say there's five shareholders, creating a holding company, family trust, all of those things may not necessarily make sense for him, because who's he going to appoint at the end of the day, right? Is it going to be his parents? Like who is there to really take away that liability, right? And then you look at, how do you hold your assets, right? Even if you've removed yourself from one level, do you still own a house that could potentially be susceptible to all of this, right? So creating those complicated structures has to be a very fulsome discussion with the accountant involved, with any insurance companies if they're thinking about getting those types of policies to protect. All of those people have to be involved in that discussion to see if it makes sense. And it's on an individual shareholder basis as well, right? You wouldn't do that type of a structure for each and every shareholder, because it might not always fit the bill.
Right. See that, Will? See that? I always wanted to be a lawyer growing up. And when I was in university, I walked into the bookstore, took the LSAT book, and got to the first question, and it was so convoluted with having to think the way Melanie's thinking that it gave me a headache and drove me to drink, and I put the book away and burned it in the fireplace. I never
it's very logical thinking. So my question though, because Dan, you're an accountant, Dan. You don't have a lawyer's mind. Lawyers' minds, but accountants all numbers, and accountants they think out. I like the way lawyers think. I don't like the way accountants think at times, especially when it comes to my own personal finances. Keep it down, man. But my point, Melanie. So let's say someone's running like a mom and pop kind of business, a family-run business. What we'll say. What your last act sort of brought to my mind was, you have a family-run business, kids taking over the business potentially, that whole mess of family. Does it make sense to incorporate, or does it depend again on the kind of business? Or if you incorporate, obviously you'll have some outside forces, an accountant and a lawyer, that will help guide them. Like how would that work if you're a family-run business?
Yeah, so I think it starts with that discussion, right? And then it goes one layer further. What does the succession planning look like? Right? So a mom and pop who have 3 kids and only 2 are interested in taking over the business. How do you balance out the succession planning so that third child still perhaps gets the inheritance associated with the business, but doesn't have to play an active role, right? So in those circumstances, if they were to choose to incorporate, it would still have all of the same players involved in that discussion, but maybe the accountant would suggest, let's freeze the business today so that we know what the value is for when mom and pa decide to move on or pass away. Right. We know that third child would be entitled to X, right? So there's so many different nuances to any given situation. But again, a shareholder incorporating or creating shareholder agreements or doing anything in that corporate spectrum really boils down to a discussion where all of the players are involved, right? That's
great. Now to real estate, which is what I know.
Yeah.
Let's discuss, you're hearing now in the news, people are, the market is slow. We know it is. We're dealing with a pandemic. However, there are still transactions that are happening. Yes. People have fears. You sign a contract that someone might back out. You try not to close a deal. What are you seeing in your practice? What are you hearing with your colleagues? I would like to hear your insights.
So I know that everyone is kind of slow. We're all trying to work remotely. We're all trying to still close deals. So when you say slow, I'm thinking slower than it was maybe before this started.
Of course, yeah.
As far as real estate generally, we're still getting, purchases, sales. A ton of refinances are coming in right now.
Right.
People are just trying to get themselves in a better standing while all of this is happening. But we're still business as usual. I think the biggest point to take away from the real estate world is just trying to figure out how we can all communicate better, right? So there's the real estate agent, there's the mortgage broker, there's us, then there's the insurance person, then we also have the home inspector. Like, there's been so many times where it's like one piece of the puzzle is missing, and then when it comes to the closing date, we're not able to close a deal because, for instance, broker conditions weren't fulfilled. One thing was missing, or we missed one of the amendments. It didn't get through to the lawyer's offices, and now we have to make more adjustments, and the client can't come back with the money today. right? So communication is so important between all of those community partners to make sure that we're all working towards getting the client into their new home or getting a client out of their old home, right? Just making sure that we can still close these deals and make it happen.
Yeah, because I'm seeing in some of the paperwork and stuff. There's every brokerage and even clauses I'm seeing in paperwork. There's a COVID something that's now placed within the actual. Usually it's in the schedule, but usually Schedule B or C. What kind of if I was a buyer or a seller coming to you, what kind of policy or kind of wording you want to see to cover someone in, if COVID is I think it's going to be with us for a while. What we want to see in paperwork.
So for me, I've looked at a few of those Schedule Bs where they're fairly all encompassing. Like there's if this, then that, if the mortgage doesn't fund, or if the banks are not open, or if the registry office closes. So they've seemed to tick all of the boxes that maybe would be a concern for clients.
Right.
But what I think it would be helpful to see in those types of schedules is that those escrow language, right? Like the ability for lawyers to, even though maybe the registry office isn't open, or maybe even though the bank is closed on that day or closes at 2:00, which is happening more often than not, and we can't get the banking done or whatever the case may be, that the clients can still get their key and we can still close the deal the following day, right? So that escrow language, which allows us to still operate.
Right. So you basically, I agree with you. The language is ambiguous in Schedule Bs, and what I told the bank hours is something I just realized. You don't go to a bank, but my parents are here, so parents need to banking done. You go to the bank is closed at like 4:00. Yes. They are promoting new hours. It's not new hours. Everyone's working on reduced hours. But the point I was that's a good point. So instead of having ambiguous language, basically we should have sort of a bit more directive or direct language indicating if the bank is closed, clients should still be able to get their key because the banking hours could be impacted by what's going on right now.
Yeah, absolutely. And I do think it goes back to that communication key, right? Like, so as agents are drafting that Schedule B or drafting any sort of schedule, maybe build in a paragraph that says the parties agree that, for 48 hours, it's conditional on legal review, right? And it gives us a chance to at least see it before it's firm and final.
Yeah.
Because then once we get to the day of closing and for whatever reason, we're asking for an extension, if there's not a provision within the agreement or within the schedules that we can actually rely on, then we're sort of a little bit up the creek, right? And we're trying to come up with creative solutions so that we don't end up in breach and don't get tendered on, right?
Right.
That's great. Someone not in real estate, what is the Schedule B?
So Schedule B, and Melanie will know better. Schedule B is typically what? So if I am a listing brokerage and I have a property that is listed, a Schedule B is my brokerage's rules for that listing that's attached to the listing in our system as real estate agents. Right. So Schedule B typically covers, and it's very broad, Melanie's correct, deposits, e-signatures is typically what you see. You're now seeing COVID language within it. Anything that a brokerage would handle in the transaction from the brokerage's point of view, not from the listing, but from the brokerage. That's a Schedule B. You'll also see Schedule Cs if there's so there's various schedules that cover up various different things, but a Schedule B is standard, especially in Durham region and Toronto, and where Melanie's other office is. When I've done transactions up in like far Coburg Pass up there, they don't have Schedule Bs, but again, it depends on the market.
Yeah, and we are seeing, like, the deals of the last month or so, we are seeing more Schedule Bs come up, and the language is not even as cohesive or as clear as we would see in a Durham region schedule. Right. So there's no consistency across the real estate world, which is also the challenge.
Right, and that's but basically what you're saying is that it would make sense because we Schedule A's. I mean, we all have templates in our systems. It's very consistent. Yes. But a Schedule B per brokerage fluctuates and it's different because some brokerages in Toronto try to sneak in little things about rental, equipment, rental air conditioners and contracts that really should not be the responsibility of any buyer, but it's in there. And if you're, as an agent, if you don't see that and cut it out, then that buyer of that property would be on the hook for, we're now seeing rental furnaces, rental air conditioning units that, have a cost of $200 to $300 per month on top of your hydro bill, right? So it's
right. And they're also built into the registry, right? So they're actually registered on title to the property.
right.
So if you've agreed to assume these contracts with, monthly bills, now you also have a fee to get it postponed because you are going to need a mortgage to purchase, and you can't have that rental agreement ranking in any sort of priority, right?
Exactly.
So again, it's so key from our perspective that things are a little bit uniform, but right now it's pandemonium, right?
Yeah, no, I totally agree with you. Totally agree. No, I 100%. Because every Schedule B is different, and at the end of the day, if you're in a rush, I mean, it's no excuse if you're in a rush.
Yeah.
But the market before this whole pandemic was craziness, and the Schedule B at times is something that people don't look at. But the Schedule B, in my opinion, is the most important document because that's where agents get effed if they miss a thing like rental contracts. Because people also, rent and lease anything, it seems now. The dishwashers could be, the washer and dryer could be thrown in there. And so you're, potentially adding, $600 a month in a rental fee on top of a mortgage. That all you could, if you just quickly reviewed that 1 or 2 sheet Schedule B, could have easily crossed out and minimized, any concerns for your clients down the road.
Yeah, absolutely.
Well, see, at least in this pandemonium, Will's doing you a favor by not sending in any business because he just spent all day on house party.
And that's how people come to her. Don't you worry. But people are working slower as well right now in real estate. So if they were going to buy a house, in March, I'll look. And I think people that I'll take a look here. I'll wait till June because everyone believes June is the month when everything's going to start getting back to normal. But the reality will be that in June, there will be, we're already, here's it. I'm still I'm not busy, but we're going to be Melanie's going to be run off her feet, and you already run off your feet now. Run off her feet because there's going to be 1,000 new listings, 1,000 new sales, because people know that if this pandemic comes back in the fall or early winter, you have a very short window to get a lot of stuff done for the year. So that's the dilemma. I wish you would realize that if you need to sort of move, look now passively. You see a property that works for you, go ahead with it. Because at the end of the day, we know this might probably come back in the fall and winter, and we might have another shutdown during Christmas, we'll say. That will impact everyone again.
But what are prices like right now?
Well, you're still seeing bidding wars. So I'm looking at the stats from this morning. Bidding wars, it depends on the price point and the market. So, you have Oshawa that's still doing quite well. But price point under 500,000, of course, there's going to be a lot of bidding wars happening. Higher prices, homes are sitting a bit longer, and prices are down a little bit. But we all know that this is, in my opinion, no expert, and no one's an expert on this pandemic. This is all new to us.
Yes.
That pricing is slightly off, but the reality will be that everyone knows once we get an ease of these policies, that pricing and the speed at which transactions happen will probably pick back up to where they were back at the start of March, end of February. That's what I'm seeing. Who knows? No one in this world has a crystal ball as to what's going to happen in a week to 2 weeks or 5 months from now. But that's what we're seeing in the stats.
I should probably sell my house. It smells like a Lysol factory in here. I could probably get a big bidding war. It's nice and clean.
Probably could. Now, could you keep your house clean? That's the question there. 2 kids homeschooling, right? You going for your 10-kilometer runs each day and then posting online.
I'd be very easy with the homeschooling part.
Well, I do none of that. I have no kids, and I would be exhausted by it. Melanie, how are your kids doing during this? You must be loving life.
Really? My kids? My grown children?
Yes.
My eldest is missing his friends, so that's my problem. And my youngest is loving that he's on an extended vacation.
Right, exactly. If I was a kid, I would love love to be home all the time. I would love it.
You can, but you can't do a lot of stuff. Like my daughter asks every day to go to the park.
Yeah.
Can't go to the park. Park's closed. So there's only so much fun you can like. I seriously considered the other day. I said, we're gonna sell the new trailer, sell the old trailer. I'm getting a big ass pool and a hot tub and a bar put into the backyard. That way, if this ever happens again, covered.
All right.
Right? Because
there's people that are up here that opened up their pools already. Opened their pools back in March because so the kids are swimming, and I'm like, that's a great idea. The kids could fill their entire day being in the pool, and and it'll be a lot of fun. That's a good point, man. Maybe you should sell your trailer.
I'm thinking about it. Yeah. Thinking about it. Well,
Melanie, have we covered everything, Melanie?
Yeah, I think we're good.
Like, we didn't talk about, I have another question.
One more thing.
Okay.
What, did you have a question?
Well, yeah, on wills, because we didn't talk about power of attorney, which I think is important right now to go cover off while we have people that are dealing with this pandemic and people that are
You ask your question first then, because mine's like an ender.
So, power of attorneys, how are those looking right now during this whole pandemic? And if someone suddenly got, sick, how can you sort of, deal with it?
So I do my powers of attorney the same way with the same restrictions as I do for wills, right? So it needs to be, each page needs to be witnessed, signed off on by the person granting the power of attorney as well as both witnesses. So same idea, if they can find two independent witnesses who are not named, the question is always going to come back to, did they have the capacity to give this power of attorney, right? So the calls that I'm getting surrounding powers of attorney are not necessarily those people looking to put them in place, but people looking to put them in place over someone who's already in the hospital, right? So I have, fathers calling about children who have become sick, or vice versa, kids calling about, their elderly parents who have no ability to sign or give these documents. And now we're looking at a court application, which the courts are closed, right? So how do we go about getting those powers of attorney in place for people who are already beyond capacity? And the challenge continues, right? Like there's no way that I can physically see that we can give a power of attorney until you can file that application at the court to get appointed.
Right. That's a good point. Dad, you had a question?
No, my last one was just, I wanted to, because the title of your company is Law in Motion.
That's right.
So does that mean that you move around to different areas to go and see people, or how do people get to work with you?
Yeah, so I have an office in Bowmanville at 140 Queen, and then which both of you know well. And then I have an office in Marmora, which is east on Highway 7. So it's about 3 towns east of Peterborough, and it's at 7 Forsyth Street. And so the whole concept of the firm is that I bring I bring services to clients in their homes, places of businesses, or wherever really they want to see me. So I've met clients at a restaurant, even at Tim Hortons or Starbucks. Sometimes in those circumstances, it's harder to get some privacy, but also in hospitals, long-term care facilities, in their homes, in their businesses, really whenever, wherever they want to meet, I make it a reality and bring the services to them.
Which is great, because not a lot of lawyers do that, and it makes it super, super easy than trying to get everybody together to come out to a physical office space.
Yeah, absolutely.
Well, awesome. Well, Melanie, thank you so much.
Thank you.
Again, your practice in Marmora, Ontario, right? And Bowmanville at 140 Queen, just near the downtown of Bowmanville. Beautiful building. The number, again, 905-419-0489. Website, lawinmotion.ca. And you're also on Facebook. You're all over the place. So people can very easily reach you. We thank you for your time. Great information. Awesome show today. So thank you very much.
Thank you.
Thanks, Melanie. I'll see you in the office soon.
Yes, see you guys.
Have a good day.
Bye.